right, I think we're going to go ahead and get started this morning. As I said, my name is Steve Ernst. I'm with Pace Analytical. We work with your regulatory group and consulting on some of your regulatory issues and concerns. Christella Moreno has asked us to present on Toxic Substances Control Act, TSCA, and the new modifications that have happened under the Frank R. Lautenberg Chemical Safety for the 21st Century Act. So, first off, a lot of people ask, what's happened? Why are we talking about TSCA? Well, on June 22nd, 2016, President Obama signed into law the Frank R. Lautenberg Chemical Safety 21st Century Act, which amends the Toxic Substances Control Act, the nation's primary chemicals management law. The act became effective immediately, June 22nd, 2016. And for the first significant amendment in its 40-year lifetime, TSCA is now a much more functioning regulatory statute. So a brief history of TSCA. TSCA is in the U.S. Code of Federal Regulations at 2601 to 2692. It was originally enacted in 1976, It was designed to regulate chemicals that pose an unreasonable risk of harm to human health or the environment. It was designed originally to fill a gap in the national safety for chemicals. We were looking at a significant era of regulations in the 70s. We had the FDA, the Food Safety Regulations Act in 1999, Over-the-Counter Drug Review in 1972, OSHA became a law in 1970, Consumer Product Safety, Consumer Safety Acts were initiated in 1972, and EPA was given regulatory control over pesticides in 1972. They did a Clean Air Act in 1963, so a little bit earlier than some of the other regulations. But in the 70s, we're also looking at the Clean Water Act, the Resource Conservation and Recovery Act, which many of you may know handles wastes. So there was a number of significant regulations that went into place in the 1970s. However, Congress felt that there was still a gap. They essentially felt that there was no existing regulation which would control the hazards of chemicals posed to human health and the environment prior to their introduction into production, basically before they were released on the market. So we were looking at OSHA, we were looking at already hazards that were being exposed to the worker from a chemical that was already there. Consumer Product Safety was already on the market. We were talking about labeling. Clean Water Act, we're talking about how to prevent the chemical from getting into water that's already in the marketplace by that point. So Congress wanted to have some way of controlling these risks prior to the introduction into the U.S. marketplace. So in the Act, what was TSCA intended to do? TSCA was intended to approach risks from a holistic way rather than a fragmented way. In this way, we mean we're not going to be talking about just one class of compounds, just pesticides, or just a subset of chemicals that we want to do. We want to look at them as a holistic way and as the hazards are applied to human health and environment. TSCA was designed to develop information in order to increase the understanding about toxicity of chemicals and the risks they pose. So from the very outset, TSCA was designed as an information gathering exercise. So we were going to be getting information from the users, and they would be stored by the EPA for future use. TSCA, Toxic Substance Control, apply to existing 62,000 chemicals, which they brought into the inventory of existing substances, into new chemicals, anything that was introduced after TSCA was put into place. EPA would apply and maintain an inventory that would include both of these existing and new substances. So it's a pretty broad regulation talking about chemicals and chemicals management, but who does it affect? Everyone in a very, very broad chemical industry is affected by TSCA. So if you're a manufacturer, it certainly applies to you. There's rules about how you bring new chemicals to market, where you can import, where you can export. As a processor, there are rules. In many cases, you're considered the same as a manufacturer. Distributors, because these rules all trickle down in the end-use applications, distributors are affected, exporters, importers, and ultimately even the end users are affected by the rules that TSCA lays out for chemicals. Some of you may have seen this in the safety data sheet, section 15, specific significant use restrictions for chemicals, can't discharge to water or something like that for end users. Those carry forth from the manufacturer all the way through the handling and processing phases all the way to the end user. So TSCA has some very, very significant effects across the entire market. So this is actually a listing. We're not going to go through every single one of these, so got lucky there. But this is a listing of TSCA by its individual sections. There are 31 sections. Everything in red is a section that has been modified from the original TSCA under the Lautenberg Chemical Safety Act. So you can see there's some number of very important sections here, which we will go into more detail on. Section 4 is testing of chemicals, substances, and mixtures. Section 5, manufacturing processing notices. That's new chemicals. Section 6, regulation of hazardous chemicals, substances, and mixtures. That actually regulates existing chemicals. Section 8 is reporting and retention of information. That actually contains the inventory. Section 12, exports. 13, imports. Section 14, disclosure of confidential information. That was completely rewritten. Section 18, preemption. When the federal government laws under TSCA take precedence over state laws. This became a very contentious issue for the states when we were looking at trying to enact modifications to TSCA, and in fact it took them 8 years to work out most of the issues over preemption. Section 21 is citizen petition. While this section didn't actually change under the Lautenberg Act, one of the interesting facts is that Section 21 allows a citizen to sue or form a federal case against the EPA in a citizen's court or any of the other acts under Section 4, 5, 6, and 8. So as we'll see as we go through this, one of the major reasons why TSCA was amended is that many of these sections were dysfunctional and not functioning as they were originally intended due to court cases. So when these became more functional under the Lautenberg Act, Section 21 actually took on more prominence, and certainly more prominence in our day and age than when they were originally promulgated as law in 1976. Finally, Section 26 is administration of the Act. Section 26 is sort of a catch-all where the EPA and Congress had to input a number of other things that didn't fit into other sections. Key among these is the new fees that EPA gets to charge for any of its services. So these are the main rules and acts that we're going to be looking at as we go through TSCA. They also happen to be the main things that are historically that TSCA has been utilized to regulate chemicals. So the changes are both moving forward, but also a good historical perspective for people learning about TSCA as well. Well, we kind of briefly talked about the sections and why, what TSCA does in these different areas. But one of the major questions we always get is, why are we looking at amending TSCA after 40 years? If we worked for 40 years, why not leave it alone and keep going? There were a number of places, as I've alluded to, where TSCA didn't work as it was originally written. There were court cases and battles that were fought that made these sections really unusable by the EPA. So Congress wrote the law fairly broadly. EPA had to write regulations from those laws. Those laws were then fought in court, and EPA became unable to utilize some of these. The major ones was test rules. Section 4 test rules is all about EPA's ability to require testing for chemicals. And this can apply prior to market, after market. In any section of TSCA, a test rule can be implemented. Under the old rules, it required a formal rulemaking. A rulemaking process requires EPA to write a rule, promulgate it out for public comment, to receive those comments and address every single one of those comments, and possibly do that multiple times before coming to a final actual action plan. So that entire process can take 3 to 10 years. So that was highly ineffective for regulating and requiring any sort of testing of chemicals. Section 5 is the new chemicals section. Under Section 5, there was no requirement for supplying any health and exposure data. There was no positive responses from EPA, so substances went into the EPA to be reviewed, and if nothing went wrong in the process, the EPA didn't find anything wrong after 90 days, the chemical would, quote unquote, drop onto the inventory list, but there was no actions that were positively delineated. There was no reason the EPA had to give if things were held up. So there was really no feedback from EPA during the new chemicals process. Section 6, the regulation of existing chemicals, really utterly failed to be utilized by EPA for a number of reasons. The primary one is that it required in its wording that the EPA consider a least burdensome forms of control on existing chemicals. Well, in 1983, I believe, a company called Corrosion Proof Fittings was sued by the EPA in its use of Section 6 to regulate asbestos. The EPA wanted to ban asbestos, which they felt was a very, very hazardous compound, so they went directly to banning the substance. Through a number of court cases, Corrosion Proof Fittings essentially petitioned that the EPA did not follow the least burdensome methods that were outlined in the rule and the law, and the courts agreed with them. So they annulled the EPA's decision to ban asbestos. After that, EPA essentially couldn't bring any Section 6 regulations of existing chemicals without someone fighting them on a least burdensome claim, and so they ultimately just gave up on Section 6, and in effect, no Section 6 rules were really ever effectively implemented in the 40 years that the EPA had control over Section 6 and existing chemicals. So that's a major section of the regulations. 62,000 chemicals the EPA essentially had no control over and no ability to regulate or abdicated that ability. Section 8, that's the inventory. We really didn't know the status of the substances on the list. Once things were put on the list, we had very little input as to how much or how often they were utilized. We did have, every 4 years, we call now the Chemical Data Reporting Rule. That used to be the IUR. But basically, anything over a certain volume, production volume per year, had to be reported. But anything under that, we have no information on. The last 2 reporting periods, that volume has been 25,000 pounds, but previously it's been as high as 100,000 pounds per year. So we had no clarity as to, of those initial substances that were put on the market, and even things that were put on after the initial 1976 induction, how many of those chemicals were actually used. So the inventory had a lot of gray area, and when you start looking at now regulating and being able to control and use test rules on existing substances, the inventory becomes very, very important. That is the guiding principle that EPA has to look at is if chemical substances are on or off the inventory. If they are on the inventory, then they can certainly take action on them under Section 4, 5, and 6. So it's important if you're revamping Section 4, 5, and 6 that you have an accurate inventory. And right now we weren't sure what it actually was. Section 14, confidential information, really had very, very low justification requirements for information on new substances. So there was a great deal of information that was allowed to be withheld from the public, made confidential very, very simply in the PMN process without any justification. Obviously, a number of non-governmental organizations objected to this, private citizens as well, and the EPA itself objected to how easily information could be kept confidential. So this was some of the major concerns that we had. So what Lautenberg Act did, and Lautenberg was one of the senators, along with Senator Vitter, a Republican and a Democrat, who got together to put this legislation into effect, is they formulated a plan of a number of major things that they felt should be changed about the TSCA Substances Control Act. By section, they went through and said Section 4 test rules should be much easier. Now, under the rule, EPA has the flexibility to require testing by order or consent agreement. So basically, instead of having to write a rule, EPA can write you a letter and order you to do testing, or write you a letter that says you can do testing or suffer the consequences of some sort of penalty. So usually you will consent to the testing. So the consent orders can move ahead very, very rapidly. Section 5, the EPA must now give an affirmative determination of new chemical reviews. So anytime the EPA reviews a new chemical, it must give information of why it believes the substance is either not hazardous, or if it is hazardous, under what conditions it is hazardous and what must be done to alleviate those hazards. Section 6 was majorly overhauled, so the regulation of new chemicals, they removed the least burdensome restrictions, so those were gone completely off the books. They required detailed procedures for a process that's called prioritization. So we're going to look at all the chemicals that are on the inventory and essentially determine them as high or low priority. Very similar to kind of what Canada did a few years ago. Substances that were high priority would then be looked at in more detail. Low priority were the chemicals we could very simply rule out as being of low risk. Once we determined a high or low priority substance, we were going to do a full risk evaluation on all high priority substances. The Section 8B of the inventory, basically all the substances on the inventory they felt need to be designated as active or inactive. Essentially, we're going to reset the inventory to 0, and everyone needs to notify whether or not they're manufacturing or processing a substance. Otherwise, we're going to consider it inactive, and therefore we don't need to look at it under sections for test rules or section 6 for prioritization and risk assessment, risk evaluation. So thereby saving themselves a lot of time and effort, hopefully. Section 14, confidential information. Well, they did not like any of the wording in that, so they completely rewrote that entire section. So now you cannot claim CBI, confidential business information, for any health and safety reports. There's a lot more for justification. Even when you do a new substance, at least every 4 confidential claims is going to be reviewed in detail by the EPA. In Section 18, we went into preemption and how and when TSCA would preempt the various state control laws. So by section, we were talking about this a little bit more detailed. Test rules. Changes in the Lautenberg Act removed the restrictions to issue a rule to require testing. They really changed just a very small piece of text from administrator, meaning the EPA, shall by rule require that testing be conducted, to by rule order consent agreement. This impacts Section 5 new chemicals, Section 6 prioritization hazard assessments, actually several other sections as well, because now the EPA can issue a test rule whenever it feels it's appropriate for any act under TSCA. If it doesn't know what a substance is being imported, it can require a test rule, and you have to do that testing before being allowed to be imported. Orders and consent agreements are significantly less effort and time for the EPA. They can take only a few weeks or months instead of the years that rules took. They're also supposed to require, under the test rules, that the EPA looks at these as a tiered testing approach. So we were supposed to look at testing, simplified testing first, more complex testing as the EPA became more concerned. However, that's never been the way the EPA approaches testing, and either the Section 4 test rules they've written since Lautenberg don't seem to necessarily follow that least tiered approach for testing. They tend to go more towards the more advanced tests to get, quote unquote, the final answer quicker. Section 4 test rules, they also have new requirements where we're supposed to start looking at non-vertebrate animal testing methods. So where before we would do a oral toxicity test or maybe a dermal corrosivity test, now we've been looking supposed to start looking at in vitro testing methods. And you're starting to see that come out now as there's a lot more test procedures being promulgated either by the EPA or third-party agencies, really pressing for these non-animal testing methods. This is much more of a concern in the European Union than it had been previously in the United States, and the United States felt it was time that they started implementing the non-burglary testing methodologies as well. So now we have test rules, what's new and improved. In Section 5, the manufacturing and processing notices, which we know as PMNs for new substances, there are a number of changes that came into place. Most of the existing language for Section 5 was retained, however. So there was only a small section where they changed it, but it's very, very significant to those people producing new chemicals. Now EPA has to give a public determination on all substances that they review. It's no longer a blind drop process. These determinations have become known as determination letters. They've kind of taken the place of what we used to probably call ID SNRs. But the EPA has 3 alternate determinations it can make when reviewing a new chemical. You look at if the substance, quote, presents an unreasonable risk, and at which point it would have to issue a rule to control that risk. They can also do the information that's provided is insufficient, or the substance may present an unreasonable risk, or it has substantial production and exposure volumes. So any of these 3 items will be issued as a determination letter, usually combined with a Section 4 test rule that they want to either fill in that insufficient information or in some way gather data to determine whether that material does actually truly present an unreasonable risk. Finally, the one that everyone likes to see is the substance could be determined to be not likely to present an unreasonable risk, at which point you can proceed on to production, onto the inventory. In this determination process, the EPA has standardly 90 days to do this review. However, if the substance under the new Lautenberg Act is determined to be not likely, these determinations can be made faster than 90 days, and the chemical can actually go to market even sooner than 90 days if it's determined to be not likely. So Section 6, as we discussed, looks at the existing chemicals. We're looking at prioritization, and what is prioritization? The EPA must create from the inventory process to screen the existing chemicals on the inventory as either high or low priority within 9 to 12 months from being determined for prioritization. So there's a process for selecting a chemical to be prioritized, and then a review process of 9 to 12 months. High priority substances are defined as chemical substances that the administrator, EPA, includes without consideration of costs or any other non-risk factors may present an unreasonable risk of injury, health, or the environment because of a potential hazard, potential route of exposure under conditions of use. So now we're starting to talk about conditions of use being very, very significant in this determination process. And we'll talk about conditions of use a little bit more as this presentation goes on. But also we have to look at unreasonable risks to potentially exposed or susceptible subpopulation. This particular language has permeated the very early permutations of the Lautenberg Act. So susceptible subpopulations are usually interpreted to be as young children, workers, the elderly, things of that way. But it could be any susceptible subpopulation. Low priority substances, chemicals that the administrator concludes based on the information sufficient to establish without consideration of costs and non-risk factors that such substances do not meet the standard for a high priority substance. So if you're not a high priority substance, you're a low priority substance. However, the big key here is that phrase, sufficient to establish. So what are we basing this on? This has always been based on the TSCA safety standard, which is an unreasonable risk of injury to health of the environment. You must consider hazard and exposure potential, so bioaccumulation and persistence, potentially exposed or susceptible subpopulation. Now we're looking at more information like storage near significant drinking water. This is information now EPA can tap into in this determination of a new chemical or an existing chemical from other EPA sources. Storage near significant drinking waters is a category of information that is typically collected either in some of the waste handling features or even in EPCRA reporting. So it replaces the TSCA burdensome cost-benefit safety standard, which prevented the EPA from banning asbestos, but with a pure, what they call a health-based safety standard. So we're not looking at any sort of costs or benefits that may accrue to society for using this chemical. We're only looking at the health information, health and safety information that's available. It gives EPA enhanced authority to require testing for both new and existing chemicals. So if the EPA can't, under the safety standard, determine whether the substance is bioaccumulative or persistent, under Section 4, it can ask you to test it. So you can see now some of these rules are starting to merge together and interact with each other. So there's some issues yet in prioritization that we have to work out. This is a very new rule, so EPA is still working on getting the details correct. For example, we don't know what the process will be for nominating existing chemicals to be prioritized. We do know from the law that the TSCA work plan chemicals from 2012 and 2014 have some priority of 10 of them a year. There's 345 on that TSCA work plan list. And these are the chemicals that EPA had determined to do risk assessments on in 2012, of which they got through 5. But these are the big players, the most hazardous chemicals that most people will think of. Things like methylene chloride and methylpyridine on TSCA work plan chemicals. But these are given priority. They're given 10 per year, have to be from that list. But after that, the EPA says they'll do up to 20 these a year, hopefully more, because as we see when we start looking at the inventory list, that's going to take a very long time for EPA to look at everything. Again, what's the process for nominating even new chemicals? So if we bring a new chemical to the marketplace, how long before we have to be considering prioritization? And will anyone be notified of a substance under review? Remember when we looked at the inventory section, there were 62,000 substances that were just put on the list. Nobody has direct EPA connection to those chemicals. They're on the inventory, but nobody has written a PMN. Nobody's supplied information on those chemicals, but they may be producing them in mass quantities. What happens when one of those goes into prioritization? Will anybody be notified to help defend that compound in the EPA review process? And the information requirements under prioritization to meet a low priority standard of sufficient to establish that the material is low priority would dictate that the bias will prioritize many substances as high priority. So we're going to be looking at most everything that the EPA looks at, certainly the 62,000 compounds which do not have sufficient to establish data, are going to be dictated as high priority chemicals requiring more information. So that could be a problem we need to look for as an industry moving forward. Now, after a substance is dictated as a high priority substance, EPA has to conduct what's called a risk evaluation. It says upon designating a chemical substance as a high priority substance, the EPA shall initiate a risk evaluation on the substance. Within the first year after the act was passed, the EPA must establish by rule a process to conduct risk evaluation. They indeed did that. They initiated the rule in December of 2017. However, that rule did not include really a very improved process. They essentially took the white paper that they were using for conducting the TSCA work plan chemicals and those evaluations and published that as the rule, how they were planning to proceed under risk evaluations. So, what's the process for a risk evaluation? If you go through prioritization, you've sort of done a mini risk evaluation. However, Congress, when they wrote the law, dictated to EPA that the process must contain an integrated and assess available information on hazards and explosions with conditions of use. And this has been a major contention with the industry because conditions of use, who gets to decide those? Is that the people who are representing the chemical? Is that the EPA? Is that non-government organizations? All of those have a different view of the definition of conditions of use. Manufacturers submit a chemical. This is our process. We're going to make adhesive. It's used for gluing wood together. However, if you look at a non-governmental organization, it may look at that same material and say, yes, but you could use it to glue carpet, you could use it to glue shingles, you could use it as a domestic adhesive in the home. So suddenly you start getting these conditions of use that could potentially lead to a lot more evaluation time and a lot more difficult evaluations to accurately assess the hazards for what you want to produce your chemical for. Also, the potentially exposed susceptible subpopulations. The definitions of those can be more tricky to define than simply young children, workers, or the elderly. It could be any susceptible subpopulation. We also have to look at, and Congress says we must take into account likely duration, intensity, frequency, and number of exposures. But we should be doing that with any sort of risk evaluation. So that's a fairly standard statement. Use and describe aggregate versus sentinel exposures. Well, an aggregate exposure is every exposure that you have is given equal weight in the assessment period. However, a sentinel exposure is an exposure, for example, to a susceptible subpopulation. A part of the population is more sensitive to that particular chemical, and that exposure of those particular individuals is given more weight. So obviously we want to consider chemical causes young children to become sick. We want to look at those. However, the risk evaluation process doesn't tell us how to determine whether we should use aggregate or sentinel exposures and when we should. Cost and other factors are not to be considered. So we can't look at how much the test cost or how much it's going to cost to be restricted or how much that's going to impact your business or any of these sort of factors to be considered. We have to do the risk evaluation with the EPA gives. And the EPA has to publish a scope of the risk evaluation within the first 6 months and complete it within 3 years. Well, we just talked about the prioritization of the work plan chemicals. Those have been in process since 2012, and we've completed 5, of which I think 2 are still in legal battles over. So the issue of 3 years seems to be fairly quick, considering they adopted the same procedures for doing the risk evaluation to begin with. And ultimately, if the material has a negative determination from this evaluation, the EPA must issue a rule to control that chemical's risks, whether that be warnings, record keeping, or disposal options, what have you. EPA has to issue a formal rule. Issues yet to be addressed under risk evaluation is how are we going to prioritize the 2014 risk work plan chemicals? How are we going to define conditions of use? Now, EPA has had a little bit of discussion about this lately, and they're saying that they consider conditions of use any conditions that EPA has received information on from either that chemical or similar chemicals. So they narrowed it a little bit to any potential use down to uses that have been notified already to EPA. Aggregate versus sentinel, we're still not sure during the risk evaluation what has priority. We're supposed to also consider best available science. This is the term that's thrown out in the actual rule, but it doesn't ever define what best available science is. There's also a science advisory committee on chemicals that's appointed under this rule. We're not sure what they're supposed to do, whether they're supposed to advise us on best available science or advise third parties who could do risk evaluations. There's a number of different ways that the best available science can be looked at. Also, it talks about weight of evidence, and again, does not define what the weight of evidence is. They do say that weight of evidence can and should be used in sections 4, 5, and 6, but we don't know what the actual process for a weight of evidence evaluation is. I know what I do for weight of evidence. Evaluation is different than what the EPA would consider, and maybe different than what most people would consider in these circumstances. EPA even has gone as far as to write a paper to say we're not going to define what weight of evidence is, something that just has to be determined by the scientific community. So this is a problem in the sense that they're regulating off of these factors and these statements, but not giving definitions for industry to work on. So These are things that are going to actually have to be resolved, most likely in court cases as time goes on. And finally, does the EPA have the resources to complete a risk evaluation in 3 years? Ultimately, we really don't think so. This is an example of a risk evaluation for N-methyl pyrrolidone. You can see there's a number of things that they looked at and we threw out. But this particular risk evaluation took at least 3 years, actually more than 3 years, and it still isn't final. So, this is, as of March 2015, final in one of the 5 assessments of the original 345. Final in the sense that they published it, not final in the sense that people have stopped fighting about it. So Section 8, reporting and retention, what we're going to focus on is actually the inventory, what is called the inventory reset. Under TSCA 8B, the EPA is required to compile, keep current, publish a list of each chemical substance which is manufactured or processed in the U.S., aka the inventory. Of the 85,000 chemicals that are on the list, roughly 62 to 63,000 grandfathered on the list without any review, no data. Basically, they sent out a survey and said, is this being used in industry? The industry responded and said, yes, I'm using it, and then on the list. So Lautenberg Act requires manufacturers and may require processors, depending on how you interpret the rule and whether you're determining your use as a manufacturing or a processor, to notify the EPA of each chemical substance on the list that is processed in the last 10 years. So this is actually going on right now. As of February 7th, manufacturers have to complete the list, and then processors have until October 5th to complete their notification. If you have any new materials that you've notified in that 10-year period, or prior to that, the CDI claims must be asserted and substantiated for those materials to remain as confidential. Otherwise, the EPA will roll them into the public inventory. So EPA will establish from this an active list and an inactive list based on the notification responses. Any substances which are on the inactive list after October 5th cannot be sold in commerce without notifying the EPA. We originally didn't know what notifying the EPA would mean, but right now it's a fairly simple, straightforward process to notify the substance that's active in commerce. Certainly not a PMN, certainly not a SNR. Issues to be addressed, they had to publish a rule within one year. So what the problem wasn't so much the rule, is actually the process. How were they going to gather this information, and how were they going to have this process in place? The EPA basically determined that they were going to use CDX, which is not the same as a CDR, but they were originally going to collect some data on the dates that you used the material, possibly the tonnage. However, when we got a hold of it in the public to make comments, they realized that they didn't have enough time to address all those comments, so they just essentially agreed to the comments and said, okay, we're not going to require any data, just let us know, just notify what's on the list. Now, it's becoming problematic because of those 62 to 63,000 grandfathered substances. Now, the way they've worked it out, anybody that manufactures one of those has to notify. So EPA gets information on everybody that notifies the substances. There's no single notification point. If you use it or manufacture it, then you need to notify it. Now, there's a number of places where materials are imported and they're held as confidential, and then that company in the foreign nation is going to have to notify it, possibly as a joint notification, to keep that information confidential. They are maintaining confidentiality. So that can make it very, very complicated to do something which EPA has tried to make very, very simple. It's also problematic for low-volume manufacturers. What if we only make 5,000 pounds of it or less a year? Do we need to notify? The answer is yes. As we said, it's problematic with foreign importers. Company who filed a PMN has to be within the United States. So if the U.S. PMN submitter was usually an import company, no longer exists, how will the EPA be notified of the substances? Public. Because now, foreign manufacturer, foreign country, you can't notify. It doesn't have a legal entityship in the United States notification. So the problem is fairly large right now for these foreign import companies. So this is a diagram of the EPA to the notifier, to the manufacturers, and then back. This is how the process normally worked under the normal system. The notifier would let the EPA know. However, if there's no notifier in the U.S., that foreign manufacturer, there is no way to that foreign manufacturer to keep the substance on the inventory. Now, they actually did also add a bit on the mercury inventory, and most people say, well, that doesn't affect me. I don't make mercury thermometers, things like that, so that's probably not something I need to be concerned about. Well, it is because of the new Lautenberg Act. They wrote in one of the sections, in this paragraph, notwithstanding Section 3.2b, the term mercury means unknown mercury and mercury compound. However, notwithstanding Section 3.2b, that means you're discounting those things in 3.2b, and 3.2b is the definition of everything that TSCA has considered exempt up until now. So things that were not previously on, or maybe not on the inventory under TSCA, if they have mercury in them, need to be considered. So this is a kind of a broader view of the mercury inventory. CVI, under the Act, Section 14 has been completely rewritten. There's a standard for certifying statements to support CVI. So if you want to keep anything confidential, you have to answer at least 4. There's actually a full 14 questions that are derived from these 4, but the general idea is, has your company taken responsible measures, reasonable measures to protect the CVI information? So you disclose it on a safety data sheet or a label. You probably can't claim that you're keeping things reasonably confidential. Has your company determined the information is not to be disclosed to the public under any other federal law? So if you're having to disclose something for, say, hazardous waste codes, you're disclosing that information, then you can't claim it as CVI under TSCA. I realize that's a little bit of a stretch of 2 different EPA rules, but I'm trying to make a point that if you disclose the information under any other federal law, you can't claim CVI here. You have to show that you have a reasonable basis to conclude disclosure of the information will cause substantial harm to the competitive position of your company. So you actually have to provide some numbers. Usually the best way is amount of dollars you spent on research and development, amount of dollars you spend on sales activities, developing the market, that sort of thing, and what that potential loss of market looks like to you. You also have to show that it's reasonably believe that the information is not readily discoverable through reverse engineering. So somebody can't easily reverse engineer your product. EPA did go on and say reverse engineering does not include high-level analytical tests like gas chromatogram, HPLCs, things like that. However, wet chemistry was still covered under reverse engineering. So health and safety studies cannot be protected. So any studies that you've done, like toxicity studies, you can't keep those confidential. You do have to disclose them. However, you may use CVI to protect your identity within them. CVI also does not apply to general information describing the manufacturer, aggregate volumes and ranges of aggregate volumes that you may disclose, general descriptions of processes used in manufacturing, the processing or functions of the use. Now, this doesn't mean very specific diagrams, but general diagrams of your process will still allow public. Information specific to a certain sector that would customarily be shared with the general public. So if you have a product you sell in both the workplace and in the consumer products sector, you can't disclose information in the consumer product label that you wouldn't disclose in this public workplace. So any substances currently on the TSCA inventory confidential list must be resubstantiated under the inventory reset rule, otherwise they will be added to the public list. Preemption, I'm going to go through fairly quickly because it's a very convoluted issue, but preemption basically means when federal law overrides state law. States with very strong chemical control laws fought this issue very, very fiercely. States like California felt like they had a really strong stance already for Prop 65, Safe Products Acts, so they didn't feel that the federal government should be in the place to tell them what to do to regulate the safety of their citizens. TSCA, essentially, they worked out the compromise under TSCA that TSCA cannot preempt any state law taken into effect prior to April 22nd, 2016. Any actions taken after 2003 are not effective. General preemption clauses, states cannot create a new or enforce an existing law regulation if they are likely to produce the same information required under TSCA 4, 5, or 6. So essentially, they can keep all their existing rules they have. They can't put in force any new laws or regulations which would mimic sections 4, 5, or 6. And although no state can regulate a chemical after EPA performs a risk evaluation and finds the chemical does not present unreasonable risk, nor can the state add additional regulations about a specific risk after EPA promulgates a rule addressing identified risks. So EPA is saying we are going to take the lead in chemicals, and if we regulate a chemical, you can't add on top of that. So there's some more things you can hear about pause preemption, a possible temporary period when the states are preempted while the federal government is trying to do an evaluation. EPA starts the evaluation under Section 6. This we're only talking about high priority chemicals then at that point. Expiration of time deadline establishes under Section 6. Pause preemption only applies to high priority chemicals, so not low priority. The states can request a waiver from pause preemption, but ultimately this is a legal and political issue, and the lawyers and the politicians are going to have a lot more to say about this really than industry and even the EPA itself. The idea here of the federal government preempting the state rules is really a political issue. And finally, Section 21, citizens' petitions, really hasn't changed much. Any person can petition the EPA to initiate a proceeding for the issuance, amendment, or repeal of a rule of Section 4, 5, 6, 8, or an order under those sections as well. If the EPA denies a petition, the petitioner can commence a civil action in a district court. So why is this important? Under the Lautenberg Chemical Safety Act, the EPA will soon be able to utilize Sections 4 and 6 much more effectively than they ever have before. So now citizens' petitions actually have something to petition. EPA can now really get into Section 4 orders. And so if you don't like your Section 4 order and the EPA says, well, too bad, we want you to go ahead with it, you can take them to court. There also seems to be a lower threshold for Section 5 notices, so new substances. So you're getting a lot of rules issued, or Section 4 rules under Section 5 for new chemicals. So as you are populating more information under Sections 4, 5, and 6, it gives more likelihood that citizen petitions are going to happen. But also there's a particular view that the NGOs have really gotten a hold of this and said, you know, we really want to use this Section 21 petition. And of course, when you move a ruling from EPA to a court, now the particular judge that is in charge of that case will have singular purview over what that determination is. So you're really taking out a broader approach to ruling and putting it in the hands of the judge. This can be good and it can be bad, depends on the judge you pick. So it's a little bit of a risk. Now, most people ask me, well, this doesn't seem like it's very likely. If it hasn't been used very much in the past, what's the risk? Well, it's a very big risk because the NGOs have really jumped onto this. And a company called NGO called Food and Water Watch has sued the EPA about fluorination of water. So essentially, EPA denied the petition, saying, no, we've looked at this before. We feel this, it's fairly well regulated. Unfortunately, the NGO disagreed, and they filed a petition, an amicus brief, which is basically a friend of the court. They gave the court information. Nobody in industry knew that this was going on because the court petition is between the EPA and the NGO. And what happens, the court essentially does a de novo review. It starts from the beginning, it doesn't really consider anything that's happened in the past case reviews. So the only information the court has is the amicus brief to go off of. And so far, the rulings that the judge has been considering are derived from the amicus brief that a non-governmental organization who wants to ban fluorination of water has provided. So what this means is we are essentially going to have to, as an industry, play a much more active role in perhaps providing amicus briefs on our chemicals prior to being brought towards civil courts. Otherwise, industry does not have a place at the table in that whole discussion between EPA, the court, and the NGO. And if you're not a party of those, you don't really have a chance to input. So we have to be a little bit more forward-looking. Finally, Section 26 is the biggest thing here is we looked at fees. EPA rewrites the way it can collect fees for 4, 5, 6, and 14 activities. We can look at 25% of the costs for operating these things can be charged back up to a maximum of $25 million in a service fee fund that no one else in the government can touch, so it's strictly for the use and operation of EPA. 25 million is a large number to me and you. However, to the EPA, that's not a very large number for operating these particular operations, but we also have to consider that's $25 million more than they currently have. So current budget restrictions aside, this will be a good place for the EPA to start collecting back some of those fees and keep these programs operational. So EPA is, in a certain way, self-funding these operations. The problem is they had to propose a rule by December 2016 and finalize it by June 2017. They've been so busy on the 4, 5, and 6 rules that they have not had a chance to finalize the fees. So even under the inventory reset rule, which we're currently enjoying, they could not charge a fee for inventory reset because they had not finalized the fees rule. The Act requires us to look at small businesses. We have to redefine that. So it's a whole series of negotiations with the Small Business Administration. They have to consider how to charge manufacturers, processors, and consult the regulated community. So there's some other items in Section 26 about appointing a Science Advisory Committee on Chemicals, scientific standards, and weight of evidence, covered already, but they don't do a good job of outlining and defining any of these things in Section 26. So what will all these changes mean in moving forward? We've already seen increased time and complexity in new chemicals, PMN reviews. The increased use of test rules has increased dramatically, especially in connection with Section 5 reviews. We do believe the fees are going to increase. There's going to be a lot more hazard evaluations that are going to be done on chemicals. So we have to look at that as we look at hazardous chemicals in our inventories and seeing these chemicals that we know have potential to be hazardous or perhaps know the potential to be regulated. We have to look at that coming up if these are going to be increasingly regulated. It's going to be difficulties arising in commerce from the inventory reset. There's going to be a number of chemicals which, for whatever reason, nobody notifies and they don't make it onto the inventory. So also difficulties from keeping track of what is actually on the inventory right now. Is your substances that you purchase, are they on the inventory for you to use? Even getting that answer right now from manufacturers is difficult, which causes uncertainty in a number of cases. It's going to be very difficult with imported materials because of this. The imported materials, we're not going to be able to determine whether or not they're on the active status, and I think a number of them are going to actually move to the inactive. The implementation of prioritization and hazard assessments really hasn't effectively started. They had the first 10 materials from the work plan list that they're working on, but they chose those 10 because they had all the data done. They essentially they had them as they put it in the can so that they could at least meet the timelines. So EPA hasn't effectively done this process of prioritization and hazard assessments from the start yet, so we don't know that they're going to be able to make the deadlines. So in conclusion, overall, the Frank R. Lautenberg Chemical Safety Act of the 21st century will increase the EPA's impact on the chemical industry through more complexity, more costs, more time to market, increase in possible restrictions, and the ability of NGOs to drive regulations in a way that we've never seen before. While many of these issues in TSCA Act addresses will increase safety, in some populations, these gains will come at a tremendous cost for the public. That concludes our presentation. have any questions in particular.
All participants are now in interactive talk mode.
Interactive talk mode. If you have any questions, please feel free to either email them or go ahead and just speak up. I must have done a very, very good job of presenting TSCA, no question.
Steve, you did a great job of presenting it. It's just there's so much there that our minds are swimming in thinking down the road of what this is going to lead to.
Agreed, and that's one of the reasons why we like to give this presentation, is to get people thinking about it, because for the largest part, industry really hasn't had to think about TSCA other than, as a substances in Section 15 in the SDS on the TSCA inventory, and did we make a new substance? Beyond that, TSCA has really been sort of a non-issue for the last at least 20 years. However, clearly you can see that Congress wanted to change that, and certainly the non-governmental organizations want to change it even more. So they are pressuring what is actually written right now in the TSCA regulations. They're pressuring to expand those ideas even further. So, the important point, I think, for a lot of people in industry is to understand that it's going to change. It's going to change very rapidly. Some of it's mandated by Congress, but some of it we need to, as an industry, get out in front of.
Absolutely. The regulatory things on current products, because it changes, it seems like all the time, that we have to we have some chemicals that may get on a list at some point, and we need to be ahead of that.
Mm-hmm. Oh, yes. I mean, to be honest with you, the simplest implementation that TSCA, the new Lautenberg Act, has done has been the inventory reset. And, I've been dealing with that for the last 3 months, and to tell you that is simple would be a lie. It's very, very complicated. It's a complex issue just to determine all the CAS numbers that you actually use. Manufacturers or processors, as you guys would be most likely considered, you want to keep your market open, so you want to make sure that substance is actually notified. Sometimes even trying to find what the CAS numbers are in the products that you buy is far more complex than you think, because does the safety data sheet contain all that information? Do you have full composition? Even if you do, has the manufacturer notified? How far down the line from where you're purchasing it is the actual manufacturer of that substance? Mm-hmm. So it's a very complicated issue, and it's far more complicated than I think EPA even gave consideration to. They thought it would be very simple, and even in their software to do the CDX inventory reset, it hasn't proved to be the case at all.
Well, I'm sure that there will be a lot more questions going forward, for sure.
Absolutely, and if you have any questions for me, feel free to either email me directly at steve.ernst@pacelabs.com, or you can obviously send them to Tristella, and she can try to help you, and maybe she'll ask me too. So either way, thank you all for listening.